All right, we're now moving on to the handout or the notes called Week 5, right to privacy developments up to Roe v. Wade. Um, Very interesting thing. The word privacy does not appear anywhere in the Constitution, the Bill of Rights, or any of the subsequent amendments to the Constitution. Um, Even though this is the reality that this idea of a right to privacy is not guaranteed or protected directly anywhere in the Constitution. Over the last century, it has developed into one of the most important rights that the Supreme Court has dealt with, and that citizens have come to rely on and to believe in, and it has greatly shaped the directions that our society has been taking over the last 50 or 60 years in particular. What we're going to talk about here is how this right came to be acknowledged and accepted and then worked prominently into the Supreme Court decisions that is now absolutely part of our basic fundamental constitutional law. Now, the term privacy, at the time of the writing of the Constitution and certainly in colonial times, the idea of privacy as we know it probably did not even exist. It would not have even occurred to the writers of the Constitution. Merriam-Webster's dictionary defines it as the quality or state of being apart from company or observation or seclusion. The Cambridge English Dictionary defines it as the state of being alone, the right to keep one's personal matters and relationships secret. So it is really this idea that there are parts of our lives, parts of ourselves, that if we choose, we never have to let others see, we don't have to let them in, we don't have to make them part of it, and that this does not just apply to other citizens or other individuals, but that it applies to the government, both state and local government, that certain parts of our lives are off limit and that without our permission, the governments do not have the right to enter, the right to not come in. Um, the closest that the Constitution probably comes to in terms of talking about the right to privacy is the Fourth Amendment. And the Fourth Amendment says that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause. What that is basically saying is that, and it tends to look at the right to privacy as more part of the physical reality than anything else. Our houses, our papers, our effects can be claimed to be private from the government, and that the government should not have the right to enter into our houses, enter into our offices, to grab our papers, or even seize our person, and to do anything with it unless there has been a warrant. A warrant is an order signed by a judge. Probable cause is the idea that a crime has been committed, is about to be committed, um, or is in progress at the moment. So, probable cause is the idea that there is some wrongdoing, some criminal activity afoot or recently afoot, and that in order to preserve evidence, in order to combat this criminal activity, that things may need to be seized, people may need to be arrested. Um, However, again, that's a very limited view of the idea of privacy. It basically talks about the criminal enforcement arm of the government versus individuals, and it really is kind of limited to our physical reality. That, well, yes, the police don't have the right to stop you and order you to open the trunk of your car without some probable cause, or they don't have the right to break down your door, to search your house without probable cause. But it really doesn't talk about the dealings of individuals with the government or the dealings of individuals with each other. It's a beginning of a concept of privacy, but it is limited. Um, the idea that communications, what I say to you, what you say to me, or that information could be private, developed much later than the writing of the Constitution and the writing of the Fourth Amendment. We have to basically go into the um, 1890s. And in 1890, Louis Brandeis, who was later to become one of the preeminent judges in the history of the Supreme Court, preeminent justices in the Supreme Court, Louis Brandeis in 1890 was a student at Harvard Law School. He was on the Harvard Law Review. For those of you who don't know, every major law school publishes something called a law review. And what that is it's a magazine published periodically, and it is written entirely by the students, and it is a situation where they take different cases, different statutes, different areas of the law, and do great amount of research and thinking and arguing over them, and then writing out their ideas about this area of law, and this is published. And in most law schools, there is a competition to first and foremost be on the law review staff itself. It's seen as an honor, and it has attained only by merit. You have to submit writing samples, and you have to pretty much fight to get a place to be a member on the law review at all. And then to get an article published is a very big deal, because most of these reviews are published once a year, twice a year, 4 times a year, have limited space, and certainly back in the 1890s, printing and typesetting and all that was outrageously expensive. It'd be limited as to how much information could be put in any one of these magazines. So to have your particular article or theory or analysis picked to be in the law review was a big deal. So we have in 1890, Louis Brandeis and one of his fellow students, Samuel D. Warren, wrote an article where they talked about a right to privacy, and a right to privacy, and the idea that people's ideas and statements and thoughts should be able to be protected and be able to kept out of the reach of the government, except in situations where the Fourth Amendment rules would allow some type of a court order, some type of a legally recognized, constitutionally recognized search and seizure. Brandeis and his fellow student took the position that there were many examples in common law where property rights were recognized, where rights to people to be in possession of their papers, where copyrights of books and magazines, patents and trademarks of ideas were recognized. So why could there not be a right to privacy be recognized? Why could there not be the idea that there are certain things about our lives that we are able to keep to ourselves and not have the government know what's going on, unless we give the government that permission, or unless the government has a constitutional reason for entering there. This thought, laid down in 1890, began to grow and began to develop, but it took a long time, all right? And it went along slowly. In the early part of the 20th century, in a case versus Meyer versus Nebraska, the Supreme Court was asked to review a statute passed by the state of Nebraska's legislature that required, or actually it prohibited, schools from teaching a foreign language to children below a certain age. Now, the rationale for the statute was supposedly that Nebraska had a compelling interest to ensure that all students and all of its citizens were able to speak and read and write in English. The court, however, in looking at it, cited the Due Process Clause of the 14th Amendment and the idea of something called substantive due process, that we'll talk about in a minute, to say that there was a liberty interest in the rights of parents to teach their children whatever language they wanted their children to speak. The court, this is a very early time when the court recognized rights that were not listed in the Constitution or the Bill of Rights, but which were still held by the people. And this idea of substantive due process is how the court initially began to incorporate against the states this idea that, well, there are things that exist, there are rights that exist, Many of these having to do with family life here, with educating of children within the family, of deciding what children are going to learn in school, that again are not stated in the Constitution, but they are real. They are there, and substantive due process demands that they be protected, they be recognized, and that the federal and state government not have the power to impede them without some type of a compelling state interest. Now, I should probably stop here and say that there are due processes divided into two types of situations. And again, due process is this idea that you must have the ability to redress your grievances, to bring your arguments before a court, to address the legislature, the government, to see that things change, to see that your rights are preserved. The first category of due process is procedural due process. Procedural due process is the idea that there should be standard rules, that they should be promulgated and published, that everybody should know, how do I get my case into court, how do I petition the governor, how do I bring the idea of a statute that I want to see passed to my legislator, and that somehow there is a system that exists that is logical and rational and offers people the opportunity to assert their rights and to make sure that their rights are protected. So again, think of procedure. What are the rules and regulations? How do we get stuff moving through the system, either judicially or legislatively, or by bringing petitions against the executive? So that's one aspect of due process. But the other aspect of due process is this idea of substantive due process, that again, these certain rights exist. They're kind of lying out there unwritten, but when the state or federal government tramples on one of them, we can now come into court and say, wait a minute, our due process rights are being violated. Judges, you must order the government officials to stop this. And that is what happened in Meyer versus Nebraska. The court basically ruled that the right to educate your children is left with the parents. It is not up to the state of Nebraska to decide exactly what subjects they should learn or not learn, and that they could not say that schools were unable to teach foreign languages to children or to teach in foreign languages below a certain age. That was a choice best left up to the parents, and that the parents had a right or a liberty interest to see that that happened with their children. The court in Meyer does not speak directly about the right to privacy. They don't use the word privacy, but they are cutting out this idea that there is this sphere, this circle of family life that the government doesn't have the right to intrude into. This point in time in the early part of the 20th century, there were large numbers of immigrants moving into this country, and many of them came here not speaking English. There were great efforts made to try and to get everyone to speak English and to adopt the culture, but also many immigrant groups grew up and existed and created their own schools to try and preserve the culture and the language of the places that they came from. And so there was this political tension, as can be seen here, where the Nebraska legislature basically was trying to outlaw any language other than English being utilized in Nebraska. And for the first time, we have the court really looking to say, yes, English may be the main language, the principal language in the United States. Yes, there probably is some state interest in making sure people can read and write and speak English. However, when it gets into the hearth and home, when it gets into our family life, if the family wants to speak Swedish or German or French or Russian or Polish in their homes, it's not up to the state government to start making laws that are going to infringe upon that. So again, even though they didn't call it the right to privacy, they're really beginning to say, no, there's a circle in our lives. There's a part of our lives where the government cannot intrude unless they have really important goals to accomplish, and even making sure that all children are literate and fluent in English. That's not sufficient. That's not a serious enough goal to go trampling into people's family lives in this sort of way. In 1926, the court again was asked to look at an education case called Pierce versus Society of Sisters. And in this case, the state of Oregon passed a law requiring not only that all children be educated, but that all children be educated in a public state-run school or locally run town, municipally run school, basically precluding the idea that there could be private schools, and particularly precluding the idea that there could be schools based on religious or ethnic or language differences among people. Again, stating that we need to educate everybody in the main ways of our society, the main language of English, the history that we teach. And of course, already by the 1920s, the Catholic Church, even in places as far-flung as Oregon, had begun to build Catholic schools and to establish a Catholic education system that ran parallel to the state paid for and financed public education system. So there was an immediate conflict between those two educational systems when this statute was passed. Here again, the court looked at the reality of what was going on and said that even though the Constitution doesn't say that parents have the right to raise their children without state interference, the court has found that substantive due process exists, and that such a right exists, and that substantive due process requires us to protect that right. And so therefore the state of Oregon cannot order that every child be educated in a state-run school, that private schools are allowed to exist, and that the state regulations, they may go to the extent of saying that children have to attend school and have to be educated and maybe even have to learn certain subjects, but you cannot order that this be done only in schools set up and run and controlled by the state, that parents have the freedom to make choices for alternate means of education. So again, back to this idea in Mayer that within family life at least, there is this circle that exists, that even though the Constitution didn't talk about it, the state and federal governments don't have the right to go stomping in there and to demand control. Similar to this, but a little bit different, in a case called Olmstead versus the U.S., a criminal case, and this came down in 1928, a criminal defendant was challenging their conviction where the evidence against the defendant was obtained by the police or the FBI getting what's called a wiretap on a telephone line of the defendant. Now, for those of you who live in the digital Bluetooth Wi-Fi age, this may take some explanation, but up until very recent times, telephones existed by having wire connections from the phone itself out to the street, to the telephone pole that ran to the telephone company, that had switching systems that in the early days were manually operated by operators, and that eventually came to be mechanically operated and today are computer operated if you still have a landline as such. And that so that you had a situation where if you were speaking on a telephone, you were in your house, you're in your own sphere, it was private, you could arrange it so that nobody could hear what you were saying, but in order to actually communicate your voice and your message to somebody else electronically, your information is carried over wires that leave your house and go up onto the telephone poles that are owned by this company that is not you, and then are processed through a system that is not owned by you, and eventually land and are relayed to another telephone somewhere that is not owned by you. And the defendant in this case said that under the Fourth Amendment, he had a right to not have his telephone calls monitored or recorded by any outside person without their permission, and that the police should have had to get a warrant issued upon probable cause in order to tie in and tapping alignment. The police literally would leave the telephone lines intact, but they would attach their own little set of wires so that they could listen in, almost like on a conference call, to what was going on with somebody's telephone conversations. Now, the court found, and again, looking at the First Amendment from a property right and a physical reality right, they basically found that when the wires left your house, you no longer had a privacy expectation in those wires. You didn't own the wires, you didn't control them, so that therefore whatever information you put on them was now part of the public domain. And if the police wanted to tap into your wires and collect your information, even though it may incriminate you in crimes, that was perfectly reasonable and logical. They had no issue with it. Interestingly enough, at this point, just Mr. Brandeis was now a justice. He was the same person who had written the law review about the right to privacy, and he had a very strongly worded dissent where he basically said, no, this is not correct. That when people speak on the telephone, the normal reality is that the information goes from the person speaking to the person hearing without anyone listening in, without anybody knowing what's going on. And there is a certain expectation of privacy, that you are not being snooped upon. And because of that, the Fourth Amendment should apply. And he said, basically, we cannot continue to look at the Fourth Amendment as a 18th century thing that, oh, it protects our barn and our shed and our writing desk within the house, but it has to expand as the technology expands and different ways of doing things expand. And that this should therefore have been, the court should have ruled the other way in this case and should have found that this information was collected illegally because the police did not have a warrant and they should have gotten one. Now, today, by statute, Congress very quickly changed the Supreme Court ruling here by enacting laws that said it is illegal for the police to tap phones or other communications without warrant, so that not that the Congress people had anything to hide in what they were saying on the telephones. However, it was interesting because very quickly the first laws came into effect that guaranteed privacy using electronic communication means. And again, Brandeis put language into his dissenting opinion that said, the right to be left alone is the most comprehensive of rights and the right most valued by civilized men. To protect that right, even every unjustifiable intrusion by the government upon the privacy of the individual by whatever means employed must be deemed a violation of the Fourth Amendment. So here, again, Brandeis is making it very clear that in his mind, that basically we have a right to be left alone. We have a right to have our lives be private and not spread out to the public at large if we don't want it to be, or to be snooped upon or observed by the government without a warrant for probable cause. And as we go on, we'll see that this began to grow and become the idea of what should happen and how the government should function and how we should be able to live. In 1942, there's a case called Skinner versus Oklahoma, where there was an Oklahoma statute that provided that habitual criminals could be involuntarily sterilized on the theory that criminal behavior was probably inherited, and that if we allow habitual criminals to propagate, to have children, that we will just be continuing further generations of criminal behavior. So let's stop this right now. We will sterilize people who have been convicted of being a habitual criminal and prevent them from having children. In this case, the court didn't really apply a due process argument. They didn't look at substantive due process so much as equal protection. But again, this is interesting because they go back to this idea that there are certain basic fundamental rights that are so important and so valuable and so attached to who we are as people that the government can only go trouncing in there in very rare circumstances. And here they said the right to marry and to procreate are part of the very fundamental existence and survival of the race. They're one of the most private realities of the individual, that once you take it away, there's no giving it back. There's no, you are causing irreparable injury to the person from whom you've taken this power away. And that, again, without there being a compelling state interest, this is not permissible behavior by the state. So forcibly sterilizing people is not allowed. As time went on, or actually almost contemporaneously with Skinner versus Oklahoma, in the state of Connecticut, there were very strict laws which prohibited and prevented the sale of contraceptives. Birth control pills had not really been developed yet. They came out in the 1960s. However, there are other forms of contraception, which I will not go into here. Leave it to yourselves to figure out or to learn what those are. But the basic idea was that contraceptive means and devices were illegal. It was illegal for doctors to um, assist patients in obtaining contraceptive devices. And in 1943, in Tilson versus Ullman, and in 1961, in Poe versus Ullman, Ullman was apparently the head of the Department of Health in the state of Connecticut, so he got dragged into these things to be sued. Um, the court said that it was okay for Connecticut to do this. However, Justice Harlan, in a dissent, um, scathingly said that this is not proper. And part of the language I quoted in the notes, it said the intimacy of husband and wife is necessarily an essential and accepted feature of the institution of marriage. An institution of the state must not only allow, but which is always in every age it has been, in every age it has fostered and protected. So again, it's saying that married couples have within their life together a certain sphere of privacy and a certain sphere to make decisions about having children or not having children, and that the state has no business sticking its nose into when that can happen, how that should happen, what means the couple is going to use to determine whether they have children or not. Um, in Griswold versus Connecticut in 1965, in large part based on the dissenting opinion from Ullman, the courts reversed themselves, and the Supreme Court basically threw out the Connecticut statute, in this case called Griswold versus Connecticut, 1965. The court threw out the laws that prevented married people from obtaining contraceptives, and basically said they were free to do so. The doctors were free to prescribe them or to instruct them in them. In 1972, the court in Eisenstadt versus Baird went even further and said not only for married couples, but for any adults, the court has no business prohibiting the use of contraceptives, making them illegal, or preventing doctors from prescribing them. And by that point in time, by 1972, the birth control pills had been invented and perfected and were being widely used. So Connecticut's laws were really rather retrograde at that point in time. In 1971, the court upheld a District of Columbia statute that forbid abortion except where it was necessary to preserve the health of the mother. People had challenged this statute, saying that it was overly broad, and overbreadth is another way saying a statute controls and regulates way more than it needs to obtain the state purposes. Normally, often used in First Amendment cases, but here the lawyers attempted to use it to overturn a law that severely restricted abortions within the District of Columbia. And in 1971, the Supreme Court upheld this law. However, again, for the first time, they talked about the idea that abortion was a medical procedure and that certain aspects of it, particularly whether the health of the mother was involved, needed to be left up to the woman and her doctor, that the state was treading on thin ice when they interfered here. But at that point in time, they let that law stand. Certainly in Griswold and Eisenstadt, again, we're going back to the idea of that there are certain parts of our lives that are private to ourselves in marriage, and in Eisenstadt, even not in marriage, but between consenting adults. There are areas of our lives that are private and the government has no right to intrude. All of this leads up to the case of Roe v. Wade, which has become a sort of bellwether dividing line between conservatives and liberals. It will be a large part of the argument and debate and discussion that will be going on in the confirmation hearings having to do with Amy Coney Barrett. It is many years since it was handed down, and it's still as controversial, maybe more controversial today than it was then, but it's based on these other cases that were moving around trying to figure out what is the right to privacy, what areas of our lives does the government have the right to intrude in, what areas does it have to stay out of, and all of these kind of taken together led step by step up to Roe v. Wade, which we will talk about in the next video.